Nathan Derejko is the Mauro Chair in Human Rights and Social Justice and an Assistant Professor of Law at the University of Manitoba. Welcome back, Nathan.
Thank you.
Nathan, what does international law say about the legality of preemptive strikes?
So when we're talking about preemptive strikes, we have to distinguish between two bodies of international law. One is called the jus ad bellum, and this is basically a fancy Latin term to say the law regulating the use of force or resort to force between states. Now, basically, this body of law is made up of the United Nations Charter and customary international law. The second body of international law applicable is called the jus in bello, or the law regulating the conduct during or in war. And this is primarily made up of international humanitarian law, the Geneva Conventions. Now, the two bodies of law are just separate. So no matter the lawfulness of a war under the jus ad bellum, who started the war, was it a lawful war, the jus in bello, international humanitarian law, applies equally to all parties. So when we talk about preemptive strikes, we first look at the jus ad bellum, and this is the UN Charter. And Article 2.4 of the UN Charter prohibits the threat or the use of force against the territorial integrity or political independence of any state. This is the cornerstone of the prohibition of war in international law. It's a triumph of humanity in 1945. Now, there's two exceptions to the prohibition of war in international law. The first is pursuant to a United Nations Security Council resolution under Chapter 7 authority, where the UN Security Council can identify a threat to the peace or a breach of the peace and then authorize states to intervene militarily in another country. One of the most recent examples of this was Libya, 2011. The second one is Article 51, which regulates self-defense. And this basically says that nothing in this charter shall prohibit a state's inherent right of self-defense if an armed attack occurs against that member state. So we see that in the language of the UN Charter, it says that the armed attack must occur. And so we have this interpretive debate going around on what that actually means. Is a state actually required to let the first strike actually hit it and potentially devastating consequences for its civilian population before it exercises self-defense? And so let me situate the interpretation within a range of three. There's more, but there's three that are most contextualized. The first is restrictive self-defense, and that's a literal interpretation of the text of the Charter that says you have to wait until the armed attack occurs and then you can respond to the armed attack. Now, most international lawyers and most states would say that this is far too narrow interpretation, and there's no state that's going to wait for a devastating strike before it exercises self-defense. At the other end of the spectrum is what we call preventative self-defense. And this is when a state exercises or allegedly exercises self-defense against some future indirect threat. Hasn't materialized. There's no indications that it will. It could never materialize, but it's a national security interest. Now, most states and most international lawyers would say that this is just too broad. It doesn't work in practice. It eviscerates the very foundation of the prohibition of war in international law, and it just doesn't work. We saw these debates come up early in 2003 with the Iraq War, talking about, we got to prevent them from getting a weapon of mass destruction, which they could give to a terrorist organization, which they could then strike, and this whole preventative thing. It's basically to prevent something. In the middle ground, there's what we call preemptive self-defense. And basically, this is when the attack hasn't materialized yet, but it is imminent, right? And so the whole legality of preemptive self-defense hinges on whether an armed attack is imminent. And now there's a huge discussion, as you can imagine, on what does imminent mean in that. And if you look up in the three major dictionaries, you're going to see about to happen, likely to happen, set to happen. There's no concrete or specific precise temporal time of what imminence means. And if we look at states, how they're coming around, they're very reluctant to kind of state their position on what an imminent armed attack would look like. But we can see that the accepted language is probably now around no other available options and the last window of opportunity to deflect an imminent armed attack.
So in the case of Israel, which I imagine and Netanyahu has been saying actually for decades, but that they are under imminent threat. Would this apply?
I don't think so. If we look at how we interpret imminence, we see that Iran didn't have a nuclear weapon to use. It didn't have plans in the making for an imminent armed attack against it. I think that Israel's actions would more likely fall within the preventative self-defense far off in the future. If we look at the IEAs and the previous government assessments, they were talking years to months. That is not an imminent armed attack that's coming. You can have contextual factors on, does it matter what type of weapons used? Is it an existential threat? Is it a powerful state, a weak state? All of these different things. But because there was diplomatic negotiations going on, they were supposed to meet on Sunday. There were other opportunities available. Iran does not have a nuclear weapon at this time, and so there is no imminent threat of an armed attack, which means that there's no legal basis for Israel's actions under the UN Charter. Now, what this means in practical terms is that Israel's attacks against Iran on June 13th would have breached Article 2.4 and amounted to an act of aggression, which would have activated Iran's right to self-defense against these armed attacks under international law.
Can we move to the laws of war in bello that you kind of referred to earlier, the second body of law? What is the legality of targeting nuclear facilities, which is what Israel has been doing in Iran?
Yeah. So as soon as the state decides to exercise self-defense, its conduct, what it can attack and when and how, is regulated by international humanitarian law, the jus in bello. Now, there's two things. One, nuclear facilities are civilian objects, right? Every state has a right under the Nuclear Non-Proliferation Treaty to peaceful nuclear energy. It's Article 4 and 5, regulates all of this. And because of that, states' nuclear facilities are civilians. Now, in armed conflict, if they become military objectives, if they're used for military purposes, and they become a military objective, there's a special layer of protection, and it's under the guise in international humanitarian law of dangerous forces. So installations containing dangerous forces such as dams, dikes, and nuclear facilities shall not be made the object of attack, even if they amount to a military objective, because they're attacking will release dangerous forces and have severe consequences for the civilian population. Now, of course, with all international humanitarian law, there's an exception. And the exception on nuclear facilities is if that nuclear facility is providing energy or munitions or weapons directly, consistently for the armed forces in a current armed conflict that are attacking, and there's no other way to stop it other than attacking that facility.
Which is probably what Israel is asserting.
But it's not. The facilities that have attacked there's no nuclear weapons there, so it isn't providing armaments for an armed conflict that's currently ongoing. So that argument wouldn't hold. There's a very, very, very narrow opportunity to attack a nuclear facility, even less so probably than a hospital under international humanitarian law.
And that's because of the potential damage that could occur if the facility.
Exactly. The reverberating implications on the civilian population, and with nuclear facilities, the environmental reverberating implications.
What about the targeting of nuclear scientists?
Yeah, this one hasn't attracted very much attention at all. So there would be two things. If a nuclear scientist was a member of the armed forces of a state, and they were embedded in with those armed forces and their full-time job, then they would be legitimate military targets and could be targeted. Other scientists that are working on nuclear programs or weapons programs that work for a university or a private company or a state-run research labs, those are civilians, and they must be protected from attack unless and for such time as they take a direct part in hostilities. And the building or the manufacture or our research and development of nuclear weapons or any type of weapon wouldn't in itself amount to direct participation in hostilities because it's too far removed. We have this analogy in munitions factory where we have civilians working in a munitions factory. Is it a legitimate target? Well, there's universal agreement that the munitions factory itself is a legitimate target, but the workers inside of it are civilians, and you must include them in the proportionality assessment when attacking it.
Now, Iran has said that it is targeting military and defense-related sites in Israel, though on Thursday, Iran hit a hospital in southern Israel. Iran said that it was targeting a military intelligence facility next door. Israel denied that and called that Iranian attack a war crime. What are your thoughts on that?
Yeah, this is, again, when we talk about was a specific target legitimate strike under international humanitarian law, we always it's a fact-driven analysis. So what I can say for certain is that, one, targeting hospitals directly is in breach of international humanitarian law. There's a very, very, very narrow window of circumstances, which I don't think exists in either Iran, Gaza, or Israel right now. So there's no possibility of targeting a hospital. The problem is, I think, or the challenge is that this is included for Israel, is that there's sometimes commingling of military objectives with civilian objects. So if we look at the Israeli headquarters, the IDF headquarters are in the center of North Tel Aviv. They're embedded right into a civilian area. And actually, international humanitarian law has provisions that apply outside of wartime that when states are building infrastructure, they're not supposed to build military objectives near civilian objectives. You should never build a military headquarters or command and control center in the center of a civilian area, because that is a legitimate target. Now, if the target was the military headquarters and the hospital was damaged, this is what we call collateral damage, and we do a proportionality assessment on it. This was a legitimate target. This was the damage. How that's separate from directly targeting a hospital, which is prohibited under international humanitarian law.
At the start of this conversation, you referenced America's invasion of Iraq in 2003, and some commentators are drawing parallels between what's happening between Israel and Iran and the U.S. invasion of Iraq in 2003, when the U.S. alleged that Iraq had weapons of mass destruction, and those allegations turned out to be false. So what are your thoughts on the comparison?
Yeah, it's striking because I'm what in international law, I'm what they called a war on terror kid. I began getting my PhD when the war on terror erupted, and we have this convergence of bodies of law applicable to one situation. And this generation could speak international human rights law and international humanitarian law. And what we saw then was this narrative playing out on like, they have weapons of mass destruction, it could lead to this, and we couldn't distinguish fact from fiction, truth. Stories would change, evidence would emerge at the last minute, there would be pictures, allegations of intention and future intention, all of these things. And what happened was, they basically, when what we're seeing today is they're using international law and just manipulating it to fit the context of like, we can do A, B, and C. I think what we're seeing today is even more so because there's less justification in legal terms. If we look at what the United States and the United Kingdom did during 2003 to justify the invasion of Iraq, they went through legal gymnastics to try. They tried everything from preventative self-defense to recitating old Security Council resolutions from decades ago to like looking at every tool. Now it seems like we've become so numb and so used to the breaches or the disregard for international law that we don't even try, that states aren't even trying to put out a legal justification for it. You have to go digging very deeply, and you have to know what you're looking for. And I think this is some of the problem. There's not a huge understanding of international law within the general public and what it means. And if there was, everyone could just make their own decisions. This is what international law says. This is what I see what's happening. I can't tell what's true, what's not, but in my assessment, it's A and B. But I think there's another parallel. It's not only the 2003 Iraq War, but in June of 1981, Israel struck a nuclear facility in Iraq, the Al-Sakr nuclear facility. It was the first time a country had ever directly attacked a nuclear facility. And it was based on the exact same arguments that Israel's putting forth today. Now, when this went to the UN, every state that commented on it condemned it. And both the UN General Assembly and the UN Security Council passed formal resolutions condemning it as a violation of international law, including the United States, which didn't condemn preemptive use of force, but said that it was unnecessary to preempt the strike because it hadn't exhausted diplomatic means yet, and there were ongoing negotiations.
Finally, we just have 1 minute left. We know Canadians and Manitobans have family in both Iran and Israel. Canada just finished hosting the G7 summit. So what role, if any, should Canada play in this moment when it comes to de-escalation between Israel and Iran?
I think a two-way arms embargo on Israel and Iran right now, and a condemnation and an upholding and obligations of international law. We need the political rhetoric to turn into concrete actions, and that is the first step, is a full arms embargo on both countries.
Nathan, thank you so much.
Thanks for having me.
Nathan Derejko is the Mauro Chair in Human Rights and Social Justice and an Assistant Professor of Law at the University of Manitoba.